Tim Blankenship here with divorce661.com, and we are back again today, this evening, weekdays at 5 p.m., and to handle your questions about divorce and talk about a specific topic. Tonight's topic is all about status-only judgments. This is also known as bifurcations or bifurcation of status. This is when you're doing a dissolution of just your marriage and you're not handling any of the other issues like custody, support, things of that nature. So we're going to talk about why you would need a bifurcation or why you may want to do a bifurcation or status only judgment before, during the divorce process. You may want to do a bifurcation. Perhaps you've already done a legal separation and now you need to do the divorce side of things. That is also a bifurcation. And talk to you about how to obtain it, either by agreement, stipulation, or by requesting it by the court. And then I'm going to go over the process and how to submit your judgment. And we're going to talk about some of the forms and how to complete them. So we're also going to be answering your questions. So as people come on live, we're doing these videos to answer questions about judgment rejects. If you're having issues with your divorce, if you need a quick fix, you're having documents rejected by the court, maybe you're trying to do your own divorce, go ahead and enter those questions in the chat if you do have questions. In the meantime, we will be going over the status-only judgment / bifurcation process. I will keep an eye on the comments. Again, we are also answering questions, and we're doing this weekly. Any question you may have about the divorce process, judgment forms, reject items, and just divorce in general, as long as it does not relate to providing legal advice, we will be good to go. So I'm going to just get right into this at this point. So why would you need a bifurcation, or why would you want to do a bifurcation? When would it be appropriate to do one? So there's a couple times that people will request these, and we do handle these for folks. And this is a quite complex process because it involves several steps. In addition to filing for divorce or for dissolution of your marriage, the bifurcation process requires additional documentation, stipulation, or request from the judge. You have to get permission to do it, or you agree to do it. And if you're just joining us, go ahead and in the chat, let me know if you're on YouTube or Facebook or LinkedIn. Let me know where you are listening to us. And if you have any questions, feel free to ask. I'll be answering questions today as well. So we're talking about bifurcations. So there's a couple times you may want to request a bifurcation. Let's say you already have a divorce case and you can't resolve the division of assets and debts or custody or anything else. So what will happen is when, say, parties have attorneys usually, and they're going through a highly litigated case that might be taking years, they may want to separate, and that's what bifurcate means. It's just a fancy word that means separate. Separate the dissolution. And I'm sorry, I have not shared my screen yet. I apologize for that. Here I am. I've been talking for 3.5 minutes by just showing the overlay. I apologize. So if you're going through a highly litigated case, let's say, and it's going on for years, and you're not making any progress, but you want to get the divorce side of the things, done. You want to get the marriage dissolved and then reserve all the other decisions down the road. The parties can agree. Again, I'm going to go over the different ways of doing this. You can either agree to bifurcate, or where one spouse may not want to separate the assets or separate the division of property and custody and all that from the divorce, and they want to handle everything at once, which is normally the case. Sometimes one party doesn't want to do it. They want to get everything concluded at once, which is the norm. Some people want to separate the process of the dissolution from the actual division of assets and debts. The courts, I think, if it's by stipulation, they usually allow it. They don't like bifurcations per se, from what I recall, because they know once the divorce is done, like the marriage is dissolved, that it kind of removes the pressure from handling all the other issues, and then that just kind of lingers in the court. And we're not talking about these types of bifurcations where there's no agreement to do that. We're going to be talking about how to do it by agreement, by stipulated or I should say, filing a stipulation to agree to the bifurcation. Another reason you want to do this is if you've already gone through the legal separation process and you have a judgment for legal separation, you did that because you didn't want to do the divorce for some reason. So now you need to dissolve the marriage. And so that is what we're talking about, the status only. We're going to file a petition for divorce because you have to start a new case. And this is what I tell my clients you want to be aware of is if you file, because a lot of our clients will say, what's the difference between legal separation and divorce? Should I do the legal separation first? And if you do, and that's fine, but if you later want to divorce, you need to file a brand new case number, and you kind of start all over. So just a warning on that. But let's say you already had a legal separation case completed, finalized, 6 months, a year, 10 years went by, and now you say, okay, now we want to get the divorce done. You have to do a new filing, file a new petition for divorce to dissolve the marriage. And that is still considered a bifurcation, which is interesting. So if you haven't filed for divorce before or legal separation and you file for divorce, and then you say it's a protracted settlement that you guys aren't getting through court, you want to dissolve the marriage, then you're bifurcating, you're separating the divorce from the rest of the division of assets and debts and all the other agreements you would normally make. And so you bifurcate. Well, when you have a legal separation and then you later file for divorce, it's still considered a bifurcation by the court and has to go through this special process whereby you are doing the status only stipulation to bifurcate and all this other paperwork. There's two ways of doing this, as I was mentioning. One is when the parties agree, and you would just sign a stipulation to bifurcate. So what will happen, and we'll talk about the process, you have to file a new case. You would then sign a stipulation to bifurcate. And then I'm going to go through the forms later to show you how this is done. And as far as what paperwork, there's additional paperwork to the judgment. So it's basically the same process as the divorce process. Well, it is a divorce process, but the bifurcation adds another layer of steps as far as having to prepare and sign a stipulation. You have to get basically court approval. So you're going to sign the stipulation that you guys agree to the bifurcation, and then the court will sign it, and then you can finalize your judgment as a status only judgment. The other way is we're talking is if you don't agree, again, we only handle amicable cases, so we're not dealing with this, but if parties do not stipulate to bifurcate and do a status only dissolution, you would file a request for order with the court, and you would ask the court to allow you to bifurcate. And then you have to get a hearing, serve your spouse. Your spouse will say why or why not they don't want to or do want to bifurcate. And then the judge will decide to allow to bifurcate it or not. So we've gone over the process. Now we're going to just get into the forms. So before I get into the forms, I want to explain again. Let's assume for these purposes, you already have a finalized legal separation case, and you now want to, and this is how we've helped clients get through this. People that have already had a legal separation case and now want to do the divorce. That's how we're going to address what we're going over today. And so let me just share my screen here so I can show you. I have my documents up here. So again, you're going to, let me pull this up. You're still going to, so I'm going to start from the beginning and just walk through the forms. So this is going under the process of you already have a filed legal separation case, the judgment, that case has been settled. Now you want to do the dissolution of just the marriage, just the status of the marriage. That's what status only means. So you're going to file a new petition, right? Just like you did before, file a petition, serve it, do your proof of service. And once you do that, you're going to want to file your stipulation. Now, this is a document I can share what it looks like. It's something that has to have specific legalese here, as you can see. Am I showing you on the screen? No, I'm not. So you can see this is a 6-page document that you have to know the language is not something. This is why I tell you it's highly technical, and it's a 6-page document. You have to have all this legalese in here, and that you guys would eventually sign. That goes to the court, and then the judge would sign. That then gives you permission to submit the judgment for status only dissolution. So you file your divorce, you do the proof of service, you both sign the stipulation, file a stipulation, the court signs it. And then now it's a regular divorce. You're going to do your financial disclosures. your preliminary declaratory disclosures, and then you're going to submit your judgment. Now, the nice thing about having already dealt with your legal separation case, you already handled everything. You handled your division of assets and debts, custody if there was children, child support, spouse support. All the other agreements are related to that legal separation case. So when you do the status only, it is literally the status only. You're not addressing anything from the prior agreement. You're not adding new agreements to anything. In fact, if you want to make changes to your prior agreement, you would do that under the heading and case number of the legal separation case. So once you've got to this point, I want to get directly into the judgment portion and just show you the nuance. I have several videos on how to complete your judgment in a regular divorce. A lot of the same forms are going to be utilized, and I'm going to go over just the ones that are done differently in this particular case. So in the judgment, this is when you're preparing this face sheet, this is your FL 180, this is the face sheet to the judgment. When you're doing the judgment this time, normally if you're just doing a regular divorce, you're saying it's just dissolution. But in the case of a status only, obviously, we're going to mark status only here. Everything else still gets completed the same. The respondent was served on. You enter the date. The date marital status ends. You just mark this box, and then on, you leave this blank for the court to fill in the date. So on this section here, if you have children, you're still going to list your children. You're just not going to address custody or anything like that. You're going to say something like, custody has been addressed in a legal separation case, 1, 2, 3, 4, 5. Like custody previously established in another case, and then you would put the case number and the court, and that's generally what we would do. If it's not applicable, then you're not going to complete that at all anyways. Again, spouse, you still need to have the 3 in here, but you can also say in this other box, previously established in case number XYZ. And then whatever that was in that case, that is going to follow suit. You're not going to change any of that. If it was terminate spouse support in your legal separation case, that's going to remain. You don't need, in fact, to add this additional form because it's already been established in another case. Same with property. You're just going to write the same thing that it said here, previously established in case number, blah, blah, blah. So that's going to be your face sheet. And all these additional forms that you would normally attach, like the child custody order, child support order, or property, you don't need to attach those because you're not asking for orders related to that because they've already been addressed in your legal separation case. The 190, the notice of entry of judgment, the only thing you're going to do different on this form than you would normally do in a normal divorce, you're marking dissolution, but obviously in a status only, you're marking this box. This is a very simple form, and that's how this, you would complete the addresses here. But just like you would normally do as a regular divorce, but you're marking dissolution status only. Now I want to get into the forms that are completely different when it pertains to a status only dissolution. There's 2 forms, 347 and there's a 348. And what you'll do when these are completed, when you turn your judgment and your judgment package to the court, you're going to have your 180, then your 347, and then your 348. So I just want to go over these briefly. They're pretty self-explanatory. It's just the check boxes. In fact, the most difficult part that you're not going to have access to or know how to do is going to be how to prepare and the stipulation to get approval from the court to stipulate to have this set up as a bifurcated status only judgment. But let me just go through this form. Let's assume you guys signed the stipulation, the court signed it, and you guys are at that point, and now you're submitting your judgment. You're going to mark judgment. The court grants the request of petitioner and respondent. The only reason this would be one or the other is if, like in the case where, say, the respondent did not want to bifurcate and the petitioner filed a motion for the court and he had a hearing on it and the judge agreed, then it would just be petitioner. But because we're handling amicable clients only, it's always petitioner respondent. The court orders. So what they're basically doing, the gist of this form is to reserve all future issues for later determination. So jurisdiction is reserved for later determination of all other pending issues in this case. Now, if you're bifurcating before your divorce, how do I say this? If you're bifurcating before and you've never had a legal separation case, this is why it's important, is because you're saying Yes, you are divorced, but all the other issues, custody, child support, spouse support, property division, is all reserved for future determination or later determination. Even though that may have already been addressed in your legal separation case, it still needs this form. It still needs to be prepared. So you're just going to usually what we're doing is just marking all the boxes. To be honest with you, division of property, petitioner respondent must indemnify and hold the other party harmless from taxes, reassessments, interest, and penalties. Go to page 2, health insurance. So fortunately, this particular form they've made easy so you can just check what is applicable. Usually, like I said, when we are completing the FL 347 for the status only dissolution, we are just knocking out all of the boxes, just covering it all, so the court can't come back and say, "Oh, your status only judgment's rejected because you didn't address probate, even though maybe you didn't have one." So we've always just marked all the boxes just to satisfy the court. Again, even if there's no probate, even if there's no pensions, we just mark it all so the courts don't have any questions about what's going on. And if you're just joining us, we're talking about status only judgments. We're also answering questions if you are going through a divorce or you need help with your paperwork, judgment rejects, questions about the form. So feel free in the chat to let us know what questions you might have. Social Security benefits. Again, we're just usually knocking out all of this for the court, so they don't come back asking why you didn't fill out a particular form. So this is an attachment to the 180 when you're doing a status only dissolution, as well as the 348, which we're covering now. And this is mostly as far as retirement retirement accounts are concerned. You saw in the 347 on page 1, if there are plans that need to be addressed at some point after the marriage is dissolved, then you can list those here. And basically what it's saying is that that you're automatically, I think it was on the other form, they're automatically stating that you'll receive 1/2 of the community property interest in the below listed plans. So that's the additional forms related to a bifurcation status. Now you're still going to have all the rest of the same judgment forms. If it's a default with agreement, you need to have the 165. You still need to have the 170. Declaration for default or uncontested, you still have to have your 141. So it's the same judgment package for or the same forms, I should say, as you would have for a regular dissolution. The only difference is because you already handled everything in your legal separation case, you don't have to reattach to the 180 any of the orders because that's already been addressed in the legal separation case. You're just attaching the 347, 348. And again, on the 180, all of these items here, all you have to really say is already established in legal separation case, whatever that is. And you don't have to attach the orders. And then if the court wants to, they can reference the legal separation case to see what those orders were in the legal separation case, but they're irrelevant. And again, when you file your status only dissolution, you're not going to ask for any new orders, make any changes, because it's just terminating the status of your marriage. And if you were to want to make changes, I guess I can give you the best way I can give you an example. We had clients that came to us that had previously done we did their legal separation case 5 years ago. And we did their legal separation case 5 years ago. Let me just change this up here. We did their legal separation case 5 years ago. They, obviously 5 years had gone by, and they now wanted to do the divorce. All of the terms, custody, child support, spouse support, were incorporated in there, and now we're going to do the status only dissolution. But they wanted to make changes to their agreement. So you wouldn't then, in this status only dissolution case, make some change to whatever it was, child support or custody or whatever, property division, whatever the case might be. You wouldn't make any changes at that point. You would just do your status only dissolution, and then you would do a modification to the legal separation case on that case number, because you can't change terms on the new case because there are no terms. You would change terms on the legal separation case. So that's it in a nutshell. I didn't see any questions come through tonight. We're trying to do this most weekdays at 5 p.m. and we'll go as long as we have to. Yesterday, we had some good questions come in, answering things about rejected judgments and so forth. Get your questions in before we go, and I'd be happy to answer them. Otherwise, we tune in Next time, bring your questions. We'll go over questions. See, what are we talking about tomorrow? We may not be here. Depends. I might have something going on. So just check our status on YouTube. We will set the show a few hours in advance. So you would get a notification, or you will see under our live shows that that we have something coming up, and we'll put the title of what we're doing is answering questions about your judgments, reject items, and so forth. But we also have a topic, like today was bifurcation, status only judgment. But each day we will have a topic and then something to talk about while we wait for the questions to come in. We're trying to do this as a helpful service. We know the impact with the self-help centers is difficult to get a hold of people, difficult to get help. People have long hold times. So we're trying to do this as a community service in addition to the full service divorce solution that we offer. We do this as a business as far as helping people get through the divorce process. So we also happy to take your money as well if you'd like to hire us to help you. But again, here for the free help, and we'll see you tomorrow. Please tune in. Take care.